Our next speaker is Randy Sullivan. He's a partner with Hunt & Williams, and his practice focuses on employment litigation in state and federal courts, also administrative practice for the EEOC and the NLRB. In addition to being a litigator, though, part of being an employment lawyer is advising and counseling your clients to avoid litigation. Randy received his bachelor's degree from UVA and went on to the University of Richmond, where he received his law degree. So please join me in welcoming Randy.
Good morning. I was telling John, when I came and spoke in March, I prefer being down here so I can move around a little bit, rather than being up on this incredible high podium. It sort of feels like being a judge, actually. I'm excited to be here. I know you guys have already had an action-packed morning with all sorts of good information, and hopefully I can add a little bit to that. First of all, congratulations on completing law school and making it through the bar exam and all those good things. I've already heard that quite a bit, but this is a big week. I know the ceremony tomorrow and professionalism course was really like. So I'm excited to be part of that. Not sure why, Watson Seniors is here, who's also with Hunt & Williams. So we're all enjoying coming over here for a day, spending time with you all. Let me ask, well, first of all, I wanted to comment. I was telling John that it dawned on me this morning that you all at this stage know more about substantive law from a general standpoint than you will ever know again. So I don't know if that's a good thing or a bad thing, but I think it's right now, it's incredible when you think about all you've learned substantively in law school and for the bar exam. And over time, as you tend to specialize, which most people do, at least to some extent, some of the things that you've learned, for me, everything other than labor and employment law and the litigation elements of that, I have no idea what's going on with wills and trusts and criminal law, all the various things that you learn. I will warn you, however, you all may have already had this experience. That doesn't stop your friends and neighbors and family from thinking that you know everything about the law because you're a lawyer. It's amazing to me how many people ask me for help with easements or wills or what property issues and that sort of thing. And I'm always a little embarrassed to say, I don't really know anything about any of that other than I can help you with your head one question. So anyway, enjoy the fact now that you've got this incredible broad-based knowledge and tap into that as much as you can going forward. Let me ask you, how many of you are already doing or want to do labor and employment sorts of things with your practice? Okay, we got a handful. From a broader perspective, how many of you are already doing or want to do litigation? Okay, pretty good number. How about a transactional practice? Okay. And then, as John mentioned, this overlaps, or tends to overlap, but how many of you want to focus on sort of the day-to-day client advice and counseling? Okay. How many of you want to spend a lot of time in nuclear power plants? Anybody? Okay. That's just an aside. I'll touch on that in a minute. But my main point is that the labor and employment practice really gives a great combination of all three of the areas that I just mentioned. For me personally, for some reason, the nuclear power plant part has come in there as well. But the litigation, the advice and counseling, and the transactional work all come into labor and employment practice. I'm going to touch on all three of those categories they come into because it really makes for a very enjoyable practice. I referenced the nuclear plant only in kidding because one of my first experiences was working with a number of other attorneys at Hunt & Williams. We had management side companies, and there was a big union organizing job from a utility. And so I was involved with the case before the National Labor Relations Board, one of the senior attorneys in the midst of that said, I need you to go to the nuclear plant for this utility, spend 2 or 3 weeks, develop evidence that we can put on as part of this case. And so I was excited. I'd never been to the nuclear plant at that point, and got there and asked the operations manager if I could get a tour, to whatever extent I could get a tour of the facility. And so he was happy to do that, and he did it. It was fascinating. Obviously, I couldn't go into the reactor theory, thank goodness, but walking out, there were these big machines. I don't know, some of you may have had this experience, but you have to walk up, put your hand, your feet, step in the right place, and it monitors how much radiation you've been exposed to. And of course, my reading was 0 because I hadn't been in the reactor area, but I was thinking, maybe this wasn't such a great idea to give a tour of the facility. But anyway, for some reason, I had been in 4 or 5 different nuclear plants in the meantime, typically as part of traditional labor areas, union organizing, or collective bargaining, sorts of things that I'll touch on. Let me just talk a little bit about the overall practice. And it's the 3 categories that we talked about. You have the litigation, that I'll break down a little bit more in a minute. You have a big part of it being the advice and counseling and compliance issues. And honestly, that's my favorite part of the practice. And then you have the traditional labor aspect of it, the relationship between unions and management, which also is very fascinating. And as John touched on, a big part of what we do is hope to avoid litigation. Clients call us with questions, and the advice that you give can help either to avoid litigation or help shape the facts so that litigation is easier if you get there, or more preferable. Let me give you, let's think about an example, just to sort of give you a real life sort of thing that I would give, that anyone would give who's doing labor and employment law. You get a call from a human resources manager that you've worked with quite a bit, and he or she says, we have this sales rep working in our Midwest region, just making up places. And he's really, really good in terms of the numbers. In fact, he's the top salesperson in his region. However, he's very disruptive, he's disrespectful, the managers and the employees don't like him, and they want to fire him. So I, the HR person, am calling you to see if we can do that. That's all you have at this point. Well, let's think about what sort of questions would you want to ask the manager, HR manager, if that's all the information you have. Yeah.
I want to know, what's he mean by disruptive? Is he say sexual things or?
Okay. Yeah, and that's a great question. So we asked that question, and the HR manager says, well, he doesn't respect the managers. He talks back to the managers. He has intimated a couple times that he thinks that he is subject to race discrimination, and he also has been insubordinate in meetings and saying managers aren't doing a good job, that sort of thing. What other questions? Yeah. Okay. Okay. Is there truth to what he is saying? Well, we've investigated, and no, we don't see that there's any race discrimination. Certainly, it's true that he has been insubordinate in meetings. What other questions might you have? Yeah.
Have there been any progressive disciplinary measures up until the property?
Yeah.
And have they documented some of these insubordination?
Great question. Yeah, and it's amazing how often you will get calls and managers wanting to fire people, and there is no discipline in the background, no steps, and so that's a great question. And very often, well, let's assume the answer here is, well, we've referenced a couple times in the evaluation, performance evaluation, that he is difficult from a core value standpoint, difficult to get along with, needs to work more on that. But no, there has not been any formal discipline other than that. Did you have a question?
That was actually the same question I had.
Yeah. Okay. Yeah, good question. Yes.
Whether or not the company has a policy or employee handbook and the SOC when we first started working there, addressing the travel or firing procedures.
Yeah, that's a great question. What's in effect that the employee would have gotten and signed on? And part of that being does he or she have an employment agreement? Are they at-will employees, those sorts of things. That's exactly right. Yes?
How has the company treated other people who have acted in this way before?
Okay, yeah, what sort of precedent is there? That's exactly right. Yeah, these are great questions. And then the other sort of initial question is, what are this employee's demographics? Obviously, if he is complaining of race discrimination, what is his race? And from a precedent standpoint, how have other employees, whether Caucasian, African American, whatever, how have they been treated? And these all go into the equation. I actually just had this, I got this phone call just a couple of months ago and worked through over a number of weeks, sort of figuring out how to approach it. And the conclusion was the risk was too great to terminate the employee, even though there was an awful lot of evidence that he was being disruptive and affecting other people's ability to work. But the first step was a discipline, to go ahead and get a discipline in the file. And there's always concern in this regard, the question about race discrimination allegations, there's always concern about retaliation goals. Somebody has alleged race discrimination or gender, whatever form of discrimination. When did that occur? Has that been 2 years ago? Was that last week? And you're now calling, and what the investigation show, and that sort of thing. So that's just an example of the sorts of calls that you get from a and advice standpoint that could very readily lead to, in fact, this one very well might lead to litigation if and when they be terminated, which I have a feeling is probably going to happen before too long, just because of how it's playing out. So that's one example. But these are the three categories of work, sort of buckets of things that you tend to do. The other that I should put up here is training as well. It's very common to, as an employment attorney, to go in and conduct training and help with policies for how to avoid harassment claims, how to treat employees fairly, how to avoid union organizing if it's from a management standpoint, and that sort of thing. It's a very interesting area. So, with those being sort of the three general categories, the substantive areas that we tend to deal with in the labor and employment realm, and actually, let me just stop for a second and go back to how, I don't know if this may be of interest, but how I got into labor and employment. I knew I wanted to do litigation. And just as, during the clerking process when I was in law school, got exposed to the labor and employment arena and thought the combination of having litigation with these other things seemed great. And I also really liked the fact that in labor and employment, you're dealing with a wide variety of people as you go through. You're dealing with managers, you're dealing with rank and file, if that's how we want to term them, employees who are out in the manufacturing area. You're dealing with CEOs, so you really get a broad-based perspective of how companies work and how people work. And it's very interesting. So that's how I got into the labor and employment area, even though I never took any labor and employment classes in law school. I just sort of stumbled into it by chance. The substantive areas that labor and employment deals with, a lot of them you would expect. A big area is the federal employment statutes. Probably the most common thing that we deal with are the anti-discrimination statutes, Title VII of the Civil Rights Act, which obviously prohibits discrimination based on race, religion, gender, and a handful of other categories. The Age Discrimination and Employment Act, which prohibits discrimination of those 40 and above. In all this in the employment or application for employment area. The Americans with Disabilities Act is obviously a huge area that is interesting because unlike the other anti-discrimination statutes, the ADA, which says you, an employer, can't discriminate on the basis of a disability if the individual is otherwise qualified to do the job, either with or without an accommodation. The ADA actually requires employers in some instances to treat individuals differently in order to accommodate their ability to do the job. So while the other statutes say you can't treat individuals differently, the ADA is, part of it is requiring that individuals be treated differently. So it's sort of unique in that regard. The ADA goes hand in hand with the Family and Medical Leave Act, the FMLA, which, as you all probably know, it says employees can have leave time, protected leave time, for a period of time for a serious health condition or to take care of a family member, birth of a child, adoption of a child, those sorts of things. And those two come into play a lot together. And I'll give you an example of something that we see quite a bit. Client calls and says that they have an individual who has been out on what's called intermittent leave, where they can take hours or days at a time, not in a long period. This person has migraine headaches. They have tended to miss Fridays and Mondays, which obviously raises suspicions. And their FMLA, they had up to 12 weeks that they could take in a 12-month period. The FMLA just expired. They actually called me the day that the FMLA was expiring and said, we can't tolerate this. We think that this person is improperly using this leave. Migraines are difficult to know when they're happening, but where they happen on Fridays and Mondays almost exclusively seems suspicious. And because it's expired, we want to go ahead and terminate this person. So let me just toss out to you all, what any red flags sort of jump up to you as things that we want to know more about? I'll go back to your point about precedent. How has this been treated other times? Any other things jump out to you before we say, yeah, you can go ahead and do that? Well, one of the things that comes into play a lot with that is under the Americans with Disabilities Act, because one of the requirements is to accommodate an employee's disability. And one of the accommodations that is prescribed is a reasonable period of unpaid leave. And so, when we get calls all the time along the lines of the FMLA has expired, can we terminate the person? And the first question typically is, wait a minute, what do we know about their condition? Would it be a disability under the ADA? And can we reasonably give them some additional period of time to be able to come back to work? And that really depends on what job is they're doing. Can we build with get people covered for some period of time? That sort of thing. But that's a huge area of litigation, the ADA and the FMLA, and how they intersect. And the FMLA too is very, very employee friendly in how it's written in terms of how doctors can provide notes and what the employer can ask for. And so there's a lot of calls about what can we do to get more information about what this employee's condition is and how can we help them those things. Real quickly, the other sort of big areas that we deal with, the FLSA is the Fair Labor Standards Act. That's the statute that governs wages and hours, overtime, minimum wage, how employees are classified, either exempt or non-exempt, meaning do they get overtime, do they not get overtime. And that has become a significant area of litigation in the class action arena under the FLSA. They're called collective actions. But you'll get a group of assistant managers who, at a restaurant, for example, who will say, we've been treated as exempt. We've been working 80 hours a week, have not gotten overtime. We think we're wrongly classified, and you need to pay us the overtime we've worked for the last 2 or 3 years. And an attorney will take that and become a fairly significant collective action. And we've seen that in a bunch of really very interesting arenas. For example, pharmaceutical sales representatives became a big one, where they said, we're not actually selling any of that. We're just marketing, so therefore we shouldn't be considered exempt. And you need to pay us for all the overtime that we've worked for the last couple of years. So a lot of interesting sort of academic and legal issues that come out of that. ERISA is the employee benefits area, and I will stab you on this mountain with that. I find it very tedious, very complicated, and really thankful to have this team and have millions that I can tap into for that expertise. And then OSHA, obviously, is this Occupational Safety and Health Act, and the administration deals with that. WARN Act is very specific to mass layoffs or plant closings, requires employees to give certain notice of when that's going to happen, so that employees can transition. This is a really big area of what we deal with. Any questions? I'm covering an awful lot in a very short period of time. Okay, and then the other substantive areas, obviously state law sorts of things specific to whatever state that you may be practicing in. Really significant part of this is the non-compete area, non-competition agreements, and which also includes non-solicitation of customers and employees and trade secrets, confidentiality, those sorts of things. And that's interesting because we can represent people on either side of that equation and regularly do. There are a number of situations where clients will call companies and say, we want to hire this particular individual. They have provided us with a copy of their non-competition agreement, and we want your advice on how much risk we're taking if we hire and do enforceable or not. And then we also have many situations where companies call and say, 2 of our people just left today. They've resigned and they're starting their own company, and we think they have taken our information with them. So we want to take whatever steps we can to either sue them or send a cease and desist letter. And those are always fascinating, I think, because not only do you have the written document issues, but typically you have forensic work that's done to see if in fact they have taken things on the computer or not. And that the downside is those things can be very expensive for the client, but they can also be very helpful if in fact there is wrongdoing in that regard. So that's a big area. Different states have very different perspectives of non-competes. So that does tend to be very state. And the other, we see a lot of defamation, the tort law context, a lot of defamation claims, breach of fiduciary duty, intentional infliction of emotional distress, the sorts of things that you would think of that come with that. And then there is some arena of wrongful discharge claims, although those have really sort of dwindled over the years. I was just trying to see the other areas that come into this too is privacy rights, and that includes any number of things, searches of lockers or searches of facilities and drug testing laws and those sorts of things. So they're very interesting areas in state law, but I would say there's a little bit less of that than the federal law that we're dealing with. And then obviously the traditional labor part of it, which is sort of a whole different aspect of our practice that we do. It's very distinct from the state and federal practice. The National Labor Relations Act is the governing federal law that deals with the labor and management relationship. And typically you're dealing from the gamut of union organizing that I talked about, where unions are trying to go in and get employees to vote to be represented by a union. And that has, interestingly, that has really dwindled. I think back in the 50s, something like 35% of employees are represented by unions. And today, at least in the private sector, it's like 7%. So it really has dwindled down quite a bit. There's some, in the public sector, it's quite a bit higher than that, with the post office and the like. But that's really, really interesting work. It's like a political campaign, basically, except there are limitations on what the company can do per se. In that context, obviously, if there is a union in place, then you have the whole arena of collective bargaining for contracts, grievances, handling of grievances, representing companies in arbitrations over issues that have arisen out of that relationship. And context, you can have what are called unfair labor practice claims, which are, it's a body of law that deals, for example, with an employee gets terminated and says, well, I think I was terminated because I was supporting the union or because I was a union spokesperson. And so that's litigation in and of itself, but that typically is before the National Labor Relations Board that you're dealing with that. How many of you have heard the phrase, probably most of you, in some context, protecting concerted activity? Have you heard that? Okay. Do you remember the context that you heard that?
I don't, but I can know she had to say.
Okay. How about you?
I heard it in labor law.
Labor law, okay. Yeah, I was thinking anybody who's taken labor law certainly has studied that. It has become a big area. It's always been a big area, but really has mushroomed, I think, in public awareness because of social media. And basically what protected concerted activity is there is a right for employees to band together to speak out against how they think they're being treated by their employers. So if a group of employees says, complains in some way about their employment, we don't like working this much overtime, or this work is unsafe, or whatever it may be, that's protected concerted activity, and it means they cannot be disciplined or treated negatively for doing it, for speaking out about their employment conditions. Or it can be one employee doing it on behalf of a group. And that's where, what you typically think of with protected concerted activity is a strike. Employees saying, it's not safe, or we don't have a contract in the union context, we're going to go out and strike. But now with social media, what's become a hot area of litigation is what exactly is protected concerted activity? And let me give you an example. It doesn't have to be, has nothing to do with whether there's a union representing employees. It's in any employment context. There was I'm not sure I can remember the exact facts, but there was a sales representative at a upper tier car dealership. In fact, I think it was in Michigan, if I'm remembering correctly. It was a Lexus dealership maybe, or Infiniti or something like that. And the dealership had a customer appreciation gathering for their customers with the hope of getting renewed sales and bringing people back in. And as part of that, they served hot dogs, like hot dogs and popcorn or something. And this sales rep afterwards went on his social media page, Facebook or whatever, and criticized for serving hot dogs at this sort of a function. And there were some other things said as well, but nothing of any, nothing that was overtly inappropriate. And the employee was fined for that and something else irrelevant to this discussion. But what had happened was after he posted it, one or two other people who were employees gave it a like or a thumbs up, and I think one said, I agree or something. And so the whole debate was that protected concerted activity such that the employee couldn't be fired for doing it, so the firing was inappropriate. And what do you all think? Does that sound like, a group of people complaining about a working condition, or one person complaining on behalf of a group about a working condition? Yeah.
I wouldn't think so, because it wasn't directed to the employer.
Yeah.
It was
So-
directed, as an employer myself, I'm thinking what they're doing is they're undermining the customer base. by
Yeah,
putting
that's
it on
right. They're
Facebook.
basically criticizing it looks bad for customers to see that. Okay, so yeah, you wouldn't think so. Anybody else have an opinion? Yeah.
Well, I'll agree with her, but also, not only is it not directed at the employer, those participating in the conversation who are liking it aren't necessarily fellow employees.
Yeah.
I'm assuming there's a whole host of friends outside of the workplace that would also be on that social page.
Well, that's a great point, and I wasn't clear enough. I know at least in the case, at least one of them was another employee. That's a great point, though. But yes, I'll clarify. At least one was a fellow employee. Yes.
I think it would really depend on what the precedent for court cases are. If this employee had been caught saying this at a mall or something, and someone repeated it back to the employer, sort of taking the real world and applying it digitally.
Yeah, exactly, sort of looking if it were around the water cooler and not on social media, how would it be construed? Yes?
I'd say on the other hand, a strike doesn't just come out of nothing. It has to start with a conversation with the employees. So a Facebook conversation is still a conversation.
Okay, that's a great point, yes.
I'd say the content of that discussion, though, is not directed so much at the working conditions, so much as it is a critique of their customer service.
That's a good point, too. Yeah, it's an odd, yes, go ahead.
I would think that if the statute requires that for the long term, that it's one employee acting on behalf of other employees, the other employees would have to raise the issue before we can act on behalf of the employee. Instead, you kind of raise the issue and then they came in on that.
Yeah, that's a great point as well. You are hitting on all the key points of this, and then I think that fundamentally, that's exactly right. You would expect there would be discussion beforehand, and he would be the one saying, I'll speak up on behalf of all of us. What has happened, the cases have been sort of all over the board, and I will say that, this fits under the National Labor Relations Board, and for the last couple of years, the board has been very pro-labor with its makeup. And in this case, I can't think of the name of the case, I'm pretty sure it was in Michigan, they found that in fact it was protected concerted activity. And most of the time now, when other employees, and your distinction is really a good one, but most of the time now when other employees join in and say, I like that, or I agree, or yeah, I had the same thought, or whatever, the board has said that's enough, even though it wasn't premeditated to be on behalf of the group. If others have joined in and agreed with it, then that means it's speaking on behalf of a group of employees. So anyway, that's just an example of this area of the law and how it has developed. And there's all sorts of cases now about employees going on Facebook or MySpace and criticizing their supervisor or criticizing something about the company and what is protected. And obviously part of it has to do with language being used and how it's done, but it has become a really interesting area of the law. Any questions on the traditional labor? Okay. The advice and compliance, we've touched on some of these things quite a bit already, but it really covers everything that we had talked about. I mentioned the transactional practice early on, and one of the things that really comes up quite a bit is we have corporate attorneys will call us and say, in this particular corporate transaction, there are a lot of employment agreements, or there's a union issue, where we figure out how to transition to collective bargaining agreement, or whatever the case may be. And so it's very common to get called into corporate transactions, various deals, which gives a different perspective of things. There's obviously a lot of dealing with employment contracts, whether they're at the beginning of employment, whether they're separation agreements, release of claim, somebody's leaving, the company knows there's risk, so they say, let's see if we can get a release in the context of a separation agreement, pay severance for 3 months or something. We deal quite with those. The non-compete agreements, employment policies and handbooks, and helping companies draft those in a way that complies with the law and also makes sense from their perspective. And then, just the day-to-day things about how do we comply with the FMLA, or how do we do the drug testing protocol? If somebody just tested positive, what sorts of things can we do to work with the employee through that process? And then the litigation, from our standpoint, we're much more frequently in federal court than we are in state court, but it does cover both. And with the biggest thing being the civil rights litigation, Title 7, ADA, and age discrimination tend to be the biggest arena. Although now the wage and hour collective actions are really in a good way. And then there's also the administrative side of things. We spend an awful lot of time dealing with EEOC charges of discrimination of whatever type, somewhat with state agencies that deal with discrimination as well. and then your time with NLRB, OSHA, Department of Labor, the Wage and Hour Administration, those sorts of things. So there's an awful lot of court involvement with the litigation, but probably an equal amount of dealings with administrative agencies in one form or another. Obviously sort of has its own mechanisms to it. So got a couple minutes left. Any questions? I know I've covered an awful lot of stuff. Any questions on anything or particular interest?
I have a question about wages when it comes to hourly employees and overtime. If you have two companies, corporations, and they're owned, they have the same board of directors and the same shareholders, but they engage in different types of business, like one's a construction company, one's a maintenance company. Can an employee that works 40 hours a week at a construction company who wants to get more hours then go to work at the maintenance company, and over here, at the construction company, he makes $15 an hour, and over here, at the maintenance company, they pay him $10 an hour, but then they pay him time and a half, so that's actually making 15. Is it legal to do that since they're separate companies and they're engaged in different activities, or that should be the salary?
That's a very good question. That's a very common question that comes up in terms of, can somebody work? Basically, part of it depends on the nature of the work they're doing. If the work is identical as compared to, are they doing something different with the other employer? And then part of it would also deal with your initial point about shared ownership and shared management of the two companies. If it looks like the companies are really intertwined and the person is doing the same sort of work, then that would, if there's a decent possibility that would simply be considered all part of the same work, and you would accumulate all the hours worked in both capacities.
But is it okay to pay them a different rate, would you think? I mean, they're still paying them overtime, to say, but you need to different rate.
Yeah, I don't think the rate is probably an issue. And I think it's the issue is more really the overtime part of it, and would you have to accumulate the hours because of the nature of the work being done? Because it's similar. I don't think the rate would be much of an issue.
On your federal court practice, what percentage of your cases would you say are decided in summary judgment?
Very high. It's very infrequent that we actually get to trial. Cases are either, there's a fairly healthy motion to dismiss practice with the case law from the Supreme Court 5 or 6 years ago, which increases the burden a little bit. And then in every case, for the most part, we're pursuing summary judgment because we're typically the defendant, representing the defendant. And as a practical matter, a very high percentage of cases go out in summary judgment or go out by way of settlement while summary judgment is pending. And that's most cases. I mean, it's every now and then a case goes to trial. It's not very common these days, at least in the sorts of cases that we're dealing with. So that's good and bad. It's good for the client because they're avoiding the expense of going through a trial procedure. But it's in a way it's bad for us because we're not getting that many actual trials, at least in federal court. So, yes.
Of your cases, how many or what percentage, I guess a better way to ask, I would assume that most of your cases involve larger employers rather than small business employers. And I wonder if that's true, and if it is, would it not be perhaps because employees in small businesses are more reluctant to comply?
Yeah, that's
relationships.
Yeah, interesting question. I think we certainly have clients that are bigger, but we also have clients that are smaller from a mid-size standpoint. Maybe 1,000 employees, or and every now and then we're representing someone who only has 75 or 100 employees. I think one of the it's not as common that we see issues with those. Part of that may simply be a attorney's fees, the company not wanting to spend as much money in that process. But I think your point is well taken, that employees in a smaller company oftentimes aren't as inclined to pursue
Companies
litigation.
of 20 or 50 employees.
Yeah, rather than trying to work something out through the employer first. And we certainly see that in